Guys, it's Mo from Mo in the Deep End. Sorry about that. I am trying to get a cross-stitch camera going because I have heard that maybe you guys would like to see me work while I'm, shenaniganizing as I do. But there is some more news coverage to go on the Delphi case, so I thought I would get into that today. Now, you'll have to excuse the blurriness and general smallness of the paperwork. I got this from our Discord because I am Terabad. It is one of the many, many, many things I wish to improve on getting the actual paperwork from the courthouse. I am not a perfect YouTuber yet, so I am definitely working on all of the skills I lack. But let's get into this. This comes from the defense team, so the OG defense team, Bradley Rossi, and basically he is going to be asking for a continuance, as you know from previous videos, and I will try to put this all in a playlist so it is not in crazy out of orderness and no more shenanigans. The state put in basically a motion for contempt on both of the lawyers, basically saying that they willfully and knowingly violated the gag order put in place by the court multiple times and, wanted there to be either sanctions or something else put upon them because of this action. Now, this is Bradley Rossi coming with a motion for continuance, so let's read through that. Comes now Attorney Bradley A. Rossi and respectfully requests that this court continue the February 12th, 2024 hearing on verified information of contemptuous conduct filed by prosecutor Nicholas C. McLeland on January 29th, 2024. In support of said motion, counsel states as follows. Number 1, on January 29th, 2024, Prosecutor McLeland filed a verified information of contemptuous conduct. Within said information, Prosecutor McLeland alleged that Attorney Rossi engaged in conduct that amounted to indirect contempt of court orders. 2, 3 days later, this court scheduled the state's information for hearing on February 12th, 2024 at 9 a.m. in Allen Superior Court. 3, the February 12th hearing was scheduled by the court without any consultation with Attorney Rossi's office regarding Attorney Rossi's availability. Attorney Rossi is scheduled to be out of state of Indiana on personal matters and is therefore unable to attend. 4, because of the timing of the state's filing, Attorney Rossi has only 11 days to prepare for said hearing. 5, Attorney Rossi has yet to consult with an attorney as of the date of the filing of this motion. 6, the accelerated scheduling of the hearing prohibits Attorney Rossi and or his future legal representative to conduct any meaningful discovery regarding the state's allegation, which appears to have stemmed from a quote unquote side investigation into leaked photos, see paragraphs 12 to 15 of the contempt pleading, that was conducted by same investigative team that investigated the crimes in this case. It seems only fair that Attorney Rossi would be entitled to conduct discovery on such a matter before facing sanctions that could result in Attorney Rossi's imprisonment. 7, Attorney Rossi would further report that the moving party, Prosecutor McLeland, has communicated to Attorneys Rossi and Baldwin that he will no longer engage in telephonic communications with Attorneys Rossi and Baldwin in this case. Attorney McLeland has limited all communications through email correspondence. Therefore, the flow of information between the state and Attorneys Rossi and Baldwin is limited. 8, a plain reading of IC 34-47, subsection 3 through 6, the statute articulating the potential punishment to be handed down by the court in a contempt finding, authorizes the court to punish indirect contempt by way of a fine, imprisonment, or both a fine and imprisonment. As such, Attorney Rossi is entitled to obtain representation for purposes of defending against allegations of contempt. Quote, an indirect contempt which is at issue here requires an array of due process protections, including notice and opportunity to be heard. In re Nasser, or I'm sorry, Indiana versus Nasser, and then all of the case things. Surely these protections would amount to more than 11 days of advance notice. 9. The allegations in the state information failed to accurately categorize the contemptuous behavior as being grounded in either civil contempt or criminal contempt. However, the pleading was filed within the quote unquote MR case number and not an unrelated CM or quote unquote MI cause. Moreover, the allegation is couched as quote unquote information for contemptuous behavior as opposed to a citation for contempt, and therefore it is logical to conclude that the relief sought by Prosecutor McClelland is akin to that associated with criminal contempt. And while the information does not specifically contain a prayer for relief, the pleading does reference the re-victimization of the victim's family, which has been, quote, immeasurable and incurable, end quote. This is verbiage grounded in criminal contempt. Therefore, Attorney Rossi is entitled to the appointment of a special judge pursuant to IC 34-47, subsection 3-7. And logically, the process of selecting a special judge should occur before any hearing on the allegations take place. 10. Attorney Rossi would also note that on January 27, 2024, Richard Allen, by and through his attorneys Rossi and Baldwin, filed a verified motion to disqualify Judge Francis C. Gull. Quote, "It is well settled that when an affidavit for change of judge is filed in a proper case based on bias and prejudice of the judge, the court has no direction in the matter. State X R. Ballard versus Jefferson Circuit Court of Jefferson County," and then that gives the case information. Moreover, in Ballard, the court cited the defendant for contempt for failure to comply with an order issued by the court prior to filing the request for the change of judge. This factual scenario nearly identical to the one that exists in this case. Attorney Rossi asserts that at the present time, this court has no authority to conduct a contempt proceeding of any nature. Number 11, Attorney Rossi would further note that there remains pending the issuance of full and final opinions stemming from the Indiana Supreme Court's published order of January 18th, 2024, in the case number for that. It seems only logical that no further action regarding the sorry, I only speak English and I'm still struggling, you guys. I am so sorry. It is truly a Monday of Mondayness. It seems only logical that no further action regarding the allegations of misconduct should occur until the court issues a full opinion giving further guidance regarding its order reinstating attorneys Rossi and Baldwin and the procedural circumstances surrounding this case. Ironically, the anticipated opinion in this case stems from a filing of an original action, which was also the case in Ballard referenced above. Therefore, there is precedent that the conduct of a trial judge in the face of a pending motion to disqualify is appealable in the form of the original action. And 12, there is no harm in awaiting the opinion of the Indiana Supreme Court. According to Attorney Rossi, the opportunity to consult with and affording Attorney Rossi the opportunity to consult with and retain counsel, allowing Attorney Rossi an opportunity to conduct discovery on the state's allegations, and more importantly, adjudicating Richard Allen's motion to disqualify. Wherefore, Attorney Rossi respectfully requests that the state continue the February 12, 2024 hearing on the state's verified information of contemptuous conduct and reset the matter on a date and time convenient for all parties and the court. So Attorney Rossi is A, not even going to be in the state, B, hasn't had time to consult with his lawyer and go over, hey, this was an honest mistake, this never happened, or even look at what they're using to base these potentially criminal charges that could land him in the clink. There's 11 days, and if I am reading this correctly, and look, y'all, I am just a lay person, so, you know, all the grains of salt. But once there has been a motion to disqualify a judge, and that is pending, until the judge can say, hey, according to this law and this law, I've not been biased, go suck it. It's a legal term of art. Then basically basically you're kind of on hold. You are on a holding pattern, at least for the way I'm reading it. I will ask Dave, I will ask another legal, lawfully law person, but the way I am reading and interpreting this, that, once that is in motion, that has been taken in by the, on the docket, it is in fact on the docket, in the docket, it is lawful law, that kind of everything goes on a stop until we figure out if this judge is in fact, not biased and ready to go. So things are definitely heating up. I don't see the judge not trying to skewer Attorney Rossi. I do see the Indiana Supreme Court, if she does, and again, this is just wild speculation headband of succulents, okay? Just my general opinion. But if she does try this and she attempts to imprison or sanction Attorney Rossi, I think that the state might get involved at this point. I think there's been enough going on that this is really not looking good. There is a change.org petition to remove Judge Gull. Not that I think that's going to do anything, but it does generally just show that people are getting a little tired of this very obvious, very noticeable bias. In this case, at least for those of us that see the case through this lens, that's the fun thing about these cases, is that I can watch the same case with someone and they can see all the same fact patterns and see things completely different. And that is, one of the cool things about watching cases is, or you rewatch a case and you see something completely different. So I will say that this case is definitely an entire dumpster fire. Just a normal day on the Delphi case. As usual, I hope you are all having a wonderful day, but I did want to get this out to you guys, at least letting you know that we are either going to have or not going to have a hearing on the 12th. I will try to keep you guys updated once I know if they are actually going to go through with a hearing. I would not put it past Judge Gull, because this would be almost, a mirror image of what she wanted to happen when the, attorneys, I mean, this would only be Attorney Rossi, but I would not put it past Judge Gull to allow video in this particular case on this hearing, just because it would be a dressing down of Attorney Rossi if she did go ahead with this 12th, and cite him in double, triple contempt if he doesn't show up because, he had something personal that he had to do that day. But that's just my wild speculation as a layperson, trademark not associated with, but not affiliated with LawTube. Any hoozle, have a wonderful day. I will see you guys later. Bye, guys.